My goal is to show how Bourdieu's theoretical tools might invade investigation of different positions regarding a scholarship of teaching in the field of Australian practical legal training. Bourdieu's theoretical tools include agents, field, habitus, categories of capital, symbolic violence, misrecognition. Agents can be individuals or organisations. A field is a social space formed by networks and relationships between agents. Fields have explicit and tacit rules that are felt as forces. A field's boundaries are determined by the limits at which a field's rules prevail. To use sport as an analogy, player agents take up positions in the field to play the game. They struggle to win, and they struggle to acquire, maintain or improve their capital in the actual game played and within the social field of the sport. Habitus encompasses the agent's internalisation of the rules and the conduct or practices that outwardly express those rules. Bourdieu describes habitus as intentionality without intention, as an experience and a possession that can be a collective phenomenon. The categories of capital for which agents struggle include economic, cultural, social and symbolic capital. In a specific field, some categories of capital have more value in that field than other categories. Economic capital involves command over economic resources. Cultural capital involves knowledge, experience and connections that allows an agent to know and use the values and cultural forms that take precedence in a specific field. Social capital involves group memberships, relationships and networks of support and influence, and symbolic capital involves resources based on honour, prestige or recognition. Agents struggle to establish, maintain or improve their holdings of the categories of capital identified as valuable within the field. Their habitus constrains, but not necessarily determines, their actions. The constraints of habitus involve symbolic violence. Brute force is not required to ensure agents' compliance with the rules. Symbolic violence affects the agent's habitus through indirect cultural mechanisms like customs, language, and images. Agents are complicit with the symbolic violence because they unquestioningly accept as legitimate the field rules and practices. Bourdieu describes this as misrecognition. Critics allege that Bourdieu's theory of habitus is deterministic. He says that agents' habitus is constrained, but it does not determine conduct, that agents have creative, active and inventive capacities. This is an area of my research that I intend to investigate by drawing on Michel de Certeau's theories of strategies and tactics, including La Perruque. For Bourdieu, agents embody and reproduce practices consistent with the field without consciousness of its constitution, like fish in water. When agents move to a new field, they are like fish out of water. Their habitus is disrupted by unfamiliar rules and practices and different values for the stocks of capital they hold. I propose to investigate whether the legal practitioners who become teacher practitioners are in a similar situation. Is their habitus disrupted betwixt them between the fields of law, academia and education? Alternatively, is the move from legal practitioner to teacher practitioner in practical legal training a movement between fields at all? Bourdieu's essay, The Force of Law, is his main work concerning this field. It is problematic because it is heavily influenced by the history of the French legal system and the interactions between French scholars in law and sociology. Nevertheless, Bourdieu offers interesting insights regarding the field of law and its interaction with the field of power. The field of power involves politics, which Bourdieu contends structures all other fields. However, the field of power is dependent on the field of law for its continued existence, and vice versa. Bourdieu perceived the dominant jurisprudential debate as one between legal formalism, taking its point of view from within the law and asserting its absolute autonomy, and legal instrumentalism, taking its point of view outside of the law, and it treats it as a tool in the service of dominant groups. Bourdieu, however, argued that specific power relations determine the field of law's internal logic, structuring the field and shaping the struggles within it. Further, the internal logic of the field of law reduced its autonomy by constraining the range of its possible actions and specifically legal solutions. To qualify for participation in the legal field, an agent must be technically competent to interpret the texts that sanctify a particular vision of the world. The main game, through struggles to claim the definitive interpretation of the text, involves the right to determine the law. The rules of the game avoid a brawl by demanding that whatever interpretation prevails, it must be presented as principled, based on unanimously accepted text, and expressed through linguistic procedures and modes that normalise and universalise a legal view. This arrangement facilitates a monopoly over the production of legal services and regulates entry into the field. Bourdieu identifies a structural hostility between the theorist and the practitioner in the legal field. The theorist values a doctrinal approach to the law, and the practitioner values the application of law. Bourdieu perceived that theorists prevail in civil code jurisdictions and that practitioners prevail in common law systems. Bourdieu says that the tension between theorists and practitioners produces a functional complementarity in which the academics produce the theoretical theory free of uncertainty, and practitioners interpret and adapt those theories to produce changes and innovations necessary for the legal field to survive. Symbolic struggles between legal professionals with differing skills and social influence produce legal interpretations. These struggles have social effects. They occur within the field, they shape the field, and are shaped by the field, and tend to reflect, reproduce, and reinforce assumptions inscribed by the legal field and the field of power. The assumptions and practices are so entrenched that social innovations tend to legitimate the legal field by operating only within its dominant structures and practices. Bourdieu identified three necessary and internally connected moments when using his theoretical tools to investigate such questions. Analyse the position of the field vis-à-vis the field of power. Map the objective structure of the relations between agents struggling for legitimate authority in the field. Analyse the habitus of agents, their system of dispositions, and a definite trajectory within the field by which those dispositions may be potentially actualised.